Welcome to the in-house webinar series. This is one of the many series that the East Africa Law Society is going to have. My name is Maria Goretti Nyariki, currently the treasurer, East Africa Law Society, a member of the Law Society of Kenya, working as a Registrar General at the Office of the Attorney General and Department of Justice. Today's webinar will deal with the common day challenges that the in-house lawyers experience. These challenges, the challenges that the session intends to avail skills is on ethical dilemma at the workplace, independence of legal advice by in-house counsel as a witness, managing difficult relationships with external counsel, and managing relationships at the workplace. I know this is going to be beneficial to the in-house counsel. For instance, our national bar, the Kenyan sector of the in-house counsel, we have had very many challenges. And I believe that at the end of this session, the in-house counsel will be well equipped to be able to face some of these challenges that they encounter in their everyday work experience. Now, before we proceed to the actual session, I'd like to introduce our host today, who is the president of the East Africa Law Society. His name is Mr. Bernard Oundo. He's a partner with Citadel Advocates, formerly owned and company advocates. This is a firm in Uganda that specializes in project finance, public-private partnership, legal advisory services. And before that, he had 10 years experience in the public sector, in the private unit of the Ministry of Finance, Planning and Economic Development, Uganda, and later as the legal expert with Uganda's PPP unit, which he pioneered. I wish to welcome Mr. President to start us off. Thank you.
Thank you, Goretti. Let me take this opportunity to welcome all members of the East Africa Law Society and webinar where an opportunity for us to again share experiences and hope that the experiences that will be shared today, you'll be able to learn and grow from them and make you better in-house counsel lawyers. I also think that the members who are external counsel will be able to hear from the in-house counsel on this panel on the sort of challenges that we have faced after COVID. So without wasting so much time, I will hand back to Goretti so that we can be able to start the session. Thank you so much, Goretti.
Okay, our keynote speaker is Ife Osaga Odondo. She's the head of legal, Sub-Saharan Africa, Google. Ife oversees the entire spectrum of Google's legal work in Sub-Saharan Africa. Her work includes advising the regional business, product and engineering teams on relevant legal issues, negotiating and drafting a variety of commercial agreements, dispute resolution, and representing Google before legal and regulatory stakeholders, Prior to her current place, she was General Counsel for Innovations for Poverty Action, a US think tank, where she was in charge of the organization's legal and compliance issues in the US, Asia, Latin America, and Africa. She has an extensive background in various aspects of law, having worked at the International Finance Corporation, World Bank Group, UNHCR, and Oxfam America, as well as at the law firm of Mohammed and Muigai in Nairobi, Kenya. Welcome.
Thank you very much, Madam Treasurer. Such a great pleasure to be here today, and really an honor to have the opportunity to provide the keynote at today's event. I have to say that it is really, really heartwarming to see us having more of this. A new development. It hasn't always been the case, but it's also a sign of the growing stature and prominence of in-house counsel. So really great for us to be meeting to talk about challenges and opportunities and just sharing ideas generally. So these are definitely unprecedented times. If you had told me about a year ago that I would be providing or giving a keynote speech from the comfort of my house, I might have found it very hard to believe. But these are the times in which we are in. And I also just want to commend each and every one of you for having, persevered the challenges of the times and stayed on course. And this virtual meeting really is a sign of our resilience as lawyers and as in-house counsel, that we are able to still move ahead with sharing ideas, even though business is not as usual. So really, 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 really grateful that we're able to have this time. Now, really, the session that we're having today is part of a larger conversation about, what is the role of in-house counsel and what we think that this role might look like in the next, 5, 10, 15, 20 years. So what I want to do is to encourage you to keep an open mind and be ready to learn and share. We have, all sorts of people attending, seasoned counsel, new, young in-house counsel, external counsel, and, we hope that, and actually not hope really, I am quite sure that there will be something to learn from this session based on the wonderful panelists that we have lined up and the rich wealth of experience that they bring to our conversation today. So when I was thinking about, putting together this keynote speech, I thought to myself, I thought maybe what might be useful is to probably share my journey as in-house counsel and maybe some few lessons. Definitely there are lots of lessons, but we have limited time, so I'm going to just focus on a couple, and I know that my panelists will also talk some more about other aspects of being an in-house counsel. So I've been in-house counsel for a little over 10 years. I started 10 years ago in a research think tank in New York City, and when I joined this company, I didn't come from a conventional background. I didn't come from a typical job in a legal department or from a job in a big law firm, and the people that I was competing against for the job came from very impressive global law firms with impressive work they had done, and so it was quite intimidating for me. But anyway, I went ahead and applied. So whenever you're in this situation, you should always apply, and regardless of competition, you might surprise yourself. Anyway, so one of the things that the requirements for the interview process was to actually review a legal problem that the organization had and provide a solution. So I did this, and then soon thereafter, I got the news that I had gotten the job, and I was very, very happy and pleasantly surprised. And later on, I inquired as to why did you decide on me as your candidate? And they said to me, when we gave you this problem, you were able to give us a solution. You didn't simply say that no, you can't do this, because they presented a problem A, and I said to them, you can't do it the way you'd like to do it because you'd be running afoul of certain laws. However, you are able to achieve this same objective in a different way that would be legal. So basically for them, they appreciated the fact that I was a problem solver and not a gatekeeper. For a long time, lawyers are gatekeepers. We are the ones who say yes or no, and our role ends there. But this is as increasingly that can no longer be the case for us as lawyers and increasingly as in-house counsel. So this was one of my major lessons that I learned very, very early on in my in-house career, that when you are working as in-house counsel, you are a partner to the business. You cannot be, doing business as usual. You must be willing to work with the business to find solutions to their legal issues, to help their organization or the business navigate various legal pitfalls and help them come to a way in which they're able to reach their objectives in a legal manner. Now, that was one key lesson that I learned. While I was there, well, actually in the early days, I realized that a lot of the people who came to ask me questions would be using all sorts of acronyms like RCT, which I found out was a randomized control trial, or PI, which was a principal investigator, because it was a research company. And I didn't know what these acronyms meant. And it became very clear that if I was to provide sound legal advice, I needed to understand my business intimately and my client's business intimately. And in this case, my client was the company. So I actually took time, to learn about how to run a randomized control trial, and the tools, in running a randomized control trial. I don't think I've not had any opportunity to run a randomized control trial, as a lawyer, but it was important for me to know how to do this so that I could be able to advise my business well and give them sound legal advice. So that was a second lesson. You must understand the business, your client's business intimately, and go over and above the normal street knowledge that you would have. Now, when I joined this job, I was given an office at the back, small office, a little dark, with a small window. And I thought to myself, well, they really thought that the lawyer should be away from the business. Really, you're not, their message I thought was that I wasn't really a key partner of the business. But after a while, after a few months of working with the leadership team and with the board, I was able to, to become actually a trusted counselor, because really my advice was beyond providing legal advice. It was also providing some business and some, leadership advice, that was useful to the organization. And this is, skills that I had picked on along the way from my career, because, I have been in-house counsel for 10 years, but before that, the previous years, I was doing a lot of different things, and I was able to build a number of skills that were useful to me and my role as in-house counsel. And I eventually joined the leadership team, and I was involved in actually, charting the path of this organization and ensuring that it was able to meet its objectives. So really, I want to speak a little bit about this role, because many of you might find yourself in this situation where you are a trusted counselor to the management of the company. And I think that this is a role that we have to take very, very seriously, because you contribute to ensuring that the company is able to, be a high performer or have high productivity, within a culture of integrity. The reality is that you cannot be a high performer if you don't have a culture of integrity. And as legal counsel, you cannot be a side, a person on the side, onlooker, looking at this situation. Oh, sorry. Sorry, I just had some interruption. I don't know if that's on my side. But anyway, I was going to say that you have to show, you cannot be an onlooker. You have to be intimately involved in guiding your management team and your company in ensuring that they're able to, have sustained economic growth, whatever business they are in, to ensure that they are providing superior goods and services, and that they're able to provide shareholder benefits, benefit consumers, and really benefit the consumer at large. The community at large. And you can only do this if you have a culture of integrity, which means that you ensure that the company adheres to the letter of the law. And not only the letter of the law, but also adheres to global standards, for example, things such as ethical sourcing of goods and materials, as well as standards, ethical standards such as, non-discrimination and things like that. And meaning that your role is not only managing legal risk, but also managing reputational risk, managing how the company is perceived by the community, and your communication with the community and various stakeholders. So really the role of in-house counsel is much larger than it used to be. And it is a very, very, very important role. And it is a role that I want to encourage you guys as lawyers to take seriously, because you are responsible or actually part of setting the tone, the organizational tone. For a company to be successful, they have to have the right culture, and they have to have a culture of high integrity. And you as in-house counsel have a role in ensuring that culture, okay? Ensuring that the employees, okay, have standards that they comply with. Remember, the culture of a company is set by the tone at the top. And really the way you set a proper culture is to ensure you have policies and procedures in place, internal controls, enforcement that compel people to do the right thing. Okay, and so as an in-house counsel, you're also responsible that you have the necessary compliance structure to be able to maintain integrity within your organization. So I want to challenge you guys to take this role very seriously and be sure that you are able to provide the right guidance, and right support to your company or your business or your organization or whatever client you have, in ensuring that they are able to maintain a culture of high integrity as well as high performance. And this is a role that that for a long time we thought that lawyers didn't, we left it to the business people, but really it cannot be business as usual. We have a role to play, and we should take it seriously. And by taking this role seriously, when you have a company that's high performing and operates in an environment of integrity, then you see benefits, also in the community, and you are able to maintain trust of your creditors, of your shareholders, of your consumers, and of regulators and all other people who you come in interaction with. So I won't say too much because I know my colleagues will be saying more about that, but I want to talk a little bit about, just the general challenges you see now in the 21st century. For sure, it's no longer business as usual. This meeting is great evidence of that. There have been changes to our global political and economic landscape, and business is not done like it used to be done, okay? We have new ways of working. For example, I'm sure you're all aware of the use of artificial intelligence to review documents or analyze legal documents, which is increasingly becoming very common. Also, you have new clients. Your clients are millennials. They are digital natives. They grew up at age 1 being able to swipe the phone and everything. And those are going to be clients who have different needs. And so you have to be able to ensure that you are also comfortable with technology and understand their world to be able to provide value to them. Now, also, you'll find that there's the traditional categories are blurred. Okay, like the private, there's the difference between the private and the public is blurred. The difference between we have to know, first of all, that knowing the law is not enough as in-house counsel, because you don't only give your client advice from a risk perspective. These days, as in-house counsel, you're expected to provide advice from a wider lens, where you should then have a bit of skills, know a little bit about technology, know a little bit of, company at Google, because Google is a technology company and everyday things change. And I cannot be able to provide decent advice if I do not remain learning. So every day I am always learning something new, about technology, and there really is just no way out if I am to remain relevant and to survive in the business. And for you as in-house counsel, you must remain learning and change accordingly as your business changes. The other thing I'll say is that being in-house counsel, you're in a unique position of exposure to different aspects of the business, and so it gives you the opportunity to pivot your career. Increasingly we see a lot of CEOs who have a legal background. You're able to go into business leadership positions, risk assessment, and take on just compliance roles within the company. Really, you're in an opportunity to pivot and to do new things. So whenever we think about the challenges of this new this new environment that we're working in, let us also think about the opportunities. and take advantages of those opportunities that that have been presented before us. These opportunities include, new industries that have, and new professions. Like a few years ago, data protection specialists were very few. Now it's a job that's pretty common, and it's a growing industry. And also looking at opportunities beyond beyond your legal role. So, in taking this opportunity and in your role as in-house counsel, wherever you are and whatever client you're working for, never lose sight of the public good, okay? Always do the right thing. It's not enough to do the legal thing these days, okay? And generally, you have to do the right thing. And doing the right thing means doing the legal thing, doing the ethical thing, and doing what is accepted globally, following global standards. So always remember that. And then remember that even as you are a partner of your business, you are the corporation's lawyer, okay? You're not the lawyer of the CEO or the management team. So you have a fiduciary duty to the corporation, and this is the interest that you must hold paramount. And even if you are a business partner to the corporation, you also have a higher duty to remain faithful to the letter of the law. So whatever you are doing, you must ensure that, you in representing your corporation, in advising your corporation, that you also remain faithful to the letter of the law. So in conclusion, I want to encourage all of you to do the right thing. Enjoy your work. You are in a unique position as in-house counsel. And I want to encourage you to soar to new heights, try new things, and then use your position and your skills and your opportunities to make the world a better place. Okay? Thank you very much. So now I think I'll turn it over to my other colleagues in the panel to tell you some more about the various things that are relevant for in-house counsel. Thank you very much.
Thank you. That was very insightful. We'll now move on to the next presentation by Ronald Musoni. Ronald Musoni is the head of compliance, Africa at MasterCard Foundation. He's a Pan-African legal professional with a keen interest in governance risk and compliance. He's experienced in development finance, corporate governance, and regulatory compliance in Africa. Please welcome.
Thank you. Thank you, Madam Treasurer, and thank you, President, for the opportunity that you've availed to us to not only share what we've learned along the way, but also to learn from our colleagues. And as the conversation progresses, I for one look forward to learning from everyone. So thank you very much. I was requested to speak about ethical dilemmas and the independence of internal counsel. I'll read that again. The ethical dilemmas in the workplace and the independence of legal advice by in-house counsel. And, the independence of the in-house legal counsel dovetails into the ethical dilemmas as one of the key issues that in-house lawyers struggle with. And the keynote speaker couldn't have said it better when she said that we need to go beyond the law, that we need to be integral to the business. We're not just bystanders as advisors and counselors to the business, but rather be seen and be part of the business. I absolutely agree with that, and also therein lies the challenges that in-house counsel have faced over the time. So in these next few minutes, I hope to share with you, 5 steps that I've employed in trying to navigate ethical dilemmas in my work. By way of introduction, I've been in the legal business for a little over 10 years. I spent quite a while as a corporate secretary for a couple of banks. I've worked in East and Southern Africa, and at the moment, in my present position, I oversee compliance, regulatory compliance for the MasterCard Foundation across the different countries we operate in on the continent. So thank you again. I will focus on navigating ethical dilemmas, mainly because I think that as one navigates that, they're able to also address the challenges that come with independence as an in-house counsel. So ethical dilemmas essentially stems from ethics, and as we all know, ethics is the branch of philosophy that typically deals with values relating to human conduct, with respect to rightness and wrongness of certain actions, and to the goodness and badness of the motives and ends of such actions. And that's the standard Webster dictionary definition of that. And the dilemma in ethical dilemma would, in a sense, be the challenge that arises out of the decision-making process between the alternatives, neither of which are absolutely acceptable, from an ethical perspective. So there wouldn't be a dilemma if it was a straightforward, oh, I'm going to have to do this, and from an ethical standpoint, it's agreeable. But it is a challenge if neither of the alternatives presented to you as a response, one would say are absolutely acceptable from an ethical perspective. Now, ethical dilemmas, we meet these in our daily lives. It could be in our social setups, it could be in our own homes, it could be amongst our friends, it could be, goes all the way in our workspace, and all the way to strategic decisions in a workspace and for an organization, and we deal with ethical dilemmas right from an early time as a youngster. I do remember, growing up in Uganda, we used to where a game of favorites where you choose, between, if you were on a boat and the boat capsized and there's only, 2 life jackets, but you were on the boat with your mother and your wife. Who would you give that other life? Who would you give that other life jacket? In of itself, that's an ethical dilemma. Who's more important, and who do you give it? Who do you save, and who do you decide to look away? And so right from that start, it goes on. You meet these ethical dilemmas all throughout life, and it creeps into your working life. And examples that I can think of in a work setup, it could be and for in-house counsel, it could range from a multitude of decisions that your guidance is required on. But the challenge specifically for in-house counsel is that we have the unenviable position of almost having the final say to a critical decision before that decision is taken. So you do not take the decision, but almost want to have your view that is often not what do you think or what does the law say, but is almost to validate a position And right there, one needs to be very, very careful when engaging with this. I remember during my time in the banks, one of the challenges had to always do with the decisions that impasses out of the tender committees. And somebody to try and unlock the impasse would always run to the head legal. And they would already have established decisions, or rather positions, but they would want you to either side with them or validate the way they view things. And ordinarily, this would not be a problem, only that you often run into all kinds of ethical challenges if the decision that they want you to validate isn't, from a utilitarian perspective, one that will benefit the organization, or sits in with the values of the organization, overall where the organization is going. And so these ethical issues one deals with in a workspace can be quite challenging if you don't have the tools to sort of work around resolving the dilemma. In some organizations, you do have the tools. You have a properly elaborated and well-articulated policies and procedures on how to address certain challenges. In some organizations, you have a set of values that guide the way that organization does business. And the organization is very intentional in implementing its values. And where you have a set of values that are articulate and guide the way you basically should be running the business, it can be very easy for one to sort of navigate those ethical dilemmas that present themselves. And where you don't have articulated policies and procedures, where you don't have a culture of doing things a certain way, in an ethically acceptable way, you do run into challenges. And this is where I wanted to share some of the approaches that I've taken, and in the hope that they can help someone out there, and we can possibly have a conversation around those. Okay. So, like I said, ethical challenges present themselves in a myriad of ways, and it would serve no purpose, especially the time allotted to try and discuss each one of these scenarios. But depending on whatever the ethical dilemma is, and you find yourself at the crossroads of a decision that, neither of which responses will sort of come across as absolutely ethical. How do you navigate this? So I came up with, again, from experience and reading around, with 5 ways that have worked for me. So first and foremost, determine what the dilemma is. Always, as a lawyer, interrogate and establish the facts. It's very easy to sort of be drawn into your cognitive biases. Oh, it looks like this, it must be that. And very often, if the facts are not interrogated with, the end result might be an unethically acceptable resolution to a challenge. So first and foremost, and this every lawyer knows, determine what the facts are. Interrogate and establish what the facts are. Okay, and once you've established what the dilemma is it something stemming from a denial of certain rights? Is it something that is stemming from a breach of an agreement? It could be a number of so many things. But first and foremost, determine what the facts are. And once you've determined the facts, and the facts are before you, remember your job. what are you called to do? You're not an arbitrator. You're not the you're not the manager. You're not the, you don't have the final say. Okay, you are legal counsel to the organization. What does the law say? I know that the keynote speaker mentioned that we need to go beyond the law, and therein lies the challenge for in-house counsel, because very often management does not see you as just a counsel to the business. They see you as part of the decision-making process of the business, and this could heavily impede your ability to actually give a view that goes beyond the law and remain independent. And then, for our practicing colleagues, the issues of privilege sort of setting, if you're so business and you're so integral to this making of the business, how do you involve with advice that you give? So therein lies a challenge for you. But also a second to trying to navigate the dilemmas one would be faced with. Remember what your job is. And this is you. Okay. And once you've understood what facts are, and you're very clear on what the mandate is. Hello? I seem to have been kicked out.
And we can hear you.
Oh, thank you. Thank you. Okay. Well, yes. So I was saying, once you've established the facts and you're clear on your mandate, then the next step is to consider the stakeholders in the particular decision that needs to be taken. And as you think about the stakeholders in this particular decision, think of the long term, the mid term, and the short term impact of the decision. Okay, and very often here you will have a leader request that you do things a certain way, or validate a position that really for them is as important as demonstrating loyalty. And yet, on the other hand, the requirement is perhaps that you validate a position or support a position that pushes for, say, equality. So in thinking about things like this, you're factoring in the long-term, the mid-term, and short-term impacts of that decision. And once you're comfortable with where you want to go with that, then the next step of something else to consider is, a different perspective. Because very often as lawyers, we tend to be locked into the letter of the law. And, during my time in the bank, we used to struggle with trying to align the law with the business, how the business is done versus the requirements of the law. The prudential norms of the central bank would require certain activities done. But the reality on ground is such that those activities may not be done, or may not even be sequenced as the regulator would require. And so trying to, not be an impeder of business, but rather, facilitate business. Thinking about complying and applying the law from the perspective of business, I often found that it offered different perspectives on how certain decisions could be made. And then once all of that has been factored in, once you've determined what the challenges are, essentially what the dilemma is, and you're clear on what your job is, and you've considered the interested parties in that matter, and you've decided to, say, not address the short term, but take a decision that will address the long term. Once all of that is factored in, then you may go ahead and make the, sort of navigate or make that decision that is presenting an ethical dilemma. And always bear in mind that no decision isn't with
Mr. Msomi, I hope you're just about to wind up.
Absolutely. Yes, and so once all of that has come together, you go right ahead and make the decision and be okay with the decision that has been taken. I will stop for now and look forward to questions and comments. Thank you.
I hope that you were able to finalize your presentation.
Yes.
Now we'll move on to the next presenter, who is going to take us through smart ways to manage relationships at the workplace. And this is Herbert Firocco. He is the head of legal services and company secretary at KCB Bank Burundi Limited, and he has been in that position since 2019. He joined KCB Bank in 2013 as a legal manager, and you can see he has risen now to the top after about 6 years. He holds an LLB from the University of Ngozi. He has over 14 years experience in legal practice as a career magistrate and legal counsel. He's also the vice president of the Association of Bank Lawyers of Burundi, and he's also a member of the Rotary Club in Burundi. Welcome.
Thank you. Thank you. Good afternoon, all participants. Thank you for the organizers to give us an opportunity to discuss and share our experiences. And for me, I will take through the smart ways to manage relationships at the workplace, taking from the practice and from my own experience. We've been, the in-house lawyer is involved in dealing with very various all stakeholders within an organization. The boss, from the peers, all departments, and all the other colleagues. And you have to be discussing and meeting very various type of personalities. So it's important to have working on the building the relationship you have with the teams. So there are 4 areas I think are important for to build excellent relationship with the team. I will start with maintaining professionalism. I think it's very important to have your daily work. You have to be professional, maintain integrity, and because it's a very demanding job, you need to be in whatever you do. You're providing an advice, you're giving an opinion, or attending a particular meeting where you have to give feedback. You have to maintain some level of professionalism. With the second quality I should mention is the listening skills. You have to build skills to be able to listen, because as a lawyer, in-house lawyer, it's very key to be able to receive and respect others' opinions, especially when you are not fully a specialist of a certain area. Let's say, for example, if you are looking into finance issues, it's very good to take time and sit with an accountant and be guided, because he or she is the specialist of that area. You have to consider its opinion. So listening skills, you have to build it with time. It's not something that always all lawyers have. You don't learn it from school, but you have as you get more experience, you have to be able to sit and listening to your colleagues. Another area at the workplace where you can be interested in is to work around the emotional intelligence, because you have to start knowing yourself, trying to do some work to know yourself, to know what are your strong areas, what are your weaknesses, what your gaps, and that will also enable you to understand the others easier. You have to be, you should, I should maybe recommend is to go through the trying to know the people you're working with at the workplace, maybe in your organization, in a company, and try to understand what their point of view, what has built that their point of view. So, and the fifth area is around friendship. Not friendship in a way that you have to be friends with everybody, but it's in the sense of building relations. You, as a lawyer, because you are also involved in actions. You must be approachable, at least, so that people will need to seek guidance, seek advice from you, can reach you easily, and in a sort of way you can get some friendship with your colleagues. And also, you try to also to look for how to manage your peers and your colleagues and the people who are below you, who are looking at you as a guide. You have to try to also be approachable. I think that the main areas I found are very useful in my career. I think it is also for my other colleagues. In some point, with those five let's say tips area, in those 5 areas, if you can improve on that, it will bring you at a high level. Thank you. I think we'll discuss further if there are any questions related to that.
Okay, thank you very much. I think that has been very helpful to in-house practitioners. We'll now move on to the next presenter, and he will tell us how to be a witness, when, how to go about that, all the nitty-gritties. And I know this is a challenge to in-house counsel, so it's good we have him on board today to just give us tips on how to manage that well. This will be done by Slim Abdallah. He's the president of Zanzibar Law Society, ZLS, and a council member of the East Africa Law Society. He's an experienced advocate and consultant in litigation, corporate investment laws, and general commercial transactions. He's a senior partner at Sepia Attorney and Associates. He holds an LLB from Zanzibar University and an LLM from Westminster University in the UK. Welcome.
Hello? Hello?
Proceed, we can hear you.
Thank you so much. Good afternoon to all participants. My part is very big and is an honor to be afforded with this opportunity to share some experience with you today. It's a very interesting topic, and my part for today is sharing some experience and some highlights on in-house counsel as witnesses. In my presentation, I would like to touch some few stuff. And before moving further, I would like to highlight some things, some issues to ponder, which involve, first of all, let's ask ourselves whether it is necessary for an in-house counsel to testify before the court. Again, let's ask ourselves whether it is, if it is yes, then how to do it without stepping into landmines. Honestly, it is very risky. And I will try to touch some 5 points involving what are the procedures for minimizing the chances for in-house counsel while testifying. When can an in-house counsel be involved in court matters? How should they conduct themselves during the matter? Privileged information, and when and how external counsel can be utilized. Before moving to other issues, as I mentioned, let's see what are the procedures which we can utilize, which we can employ to minimize the chances for our in-house lawyers appearing before the court and testifying. There are some techniques which are involved before trial, techniques during the trial before the testifying, and during the trial when the counsel is testifying. Beginning with some techniques during the before trial. First of all, there's an issue of trial of the counsel, and this aspect we may before commencement of the trial. It's better that in-house counsel should request the list of the witnesses to be used during the trial so that he can try to object to see himself being involved by arguing that he's an attorney to the corporation or entity, so that he's supposed to be barred from testifying against the same, his employer. Secondly, there are an issue of considering 24 hours notice of trial witnesses. In this aspect, an in-house counsel can request between the parties that every side should submit his list of witnesses 24 hours before. With this, he can afford himself an opportunity to see the list of the witnesses to be used during the trial. So then he can try to either to argue on how he can take his name out of the list, or he can have enough time to prepare himself and try to prepare himself mentally on how he can minimize the risk while testifying before the jury. Additionally, in-house counsel, he can employ settlement discussions. At this point, an in-house counsel, he can try to being involved before the trial in the matter for ADR, alternative dispute resolution, in which there will be no need of moving further
adjudication. If this will be allowed and achieved, that means the matter could be settled before moving into the full trial, in which he's going to be highly exposed for testifying against his employer. The other technique, which is very, very common in most of the Commonwealth jurisdiction, is employing the what we call pre-trial hearing. This is a common session for lawyers who have been involved in the litigation, in which lawyers can sit before a private hearing and try to discuss some matters to be raised during the full hearing. For instance, in Tanzania, pre-trial hearing involved the session between the jury, or they say the judge, and two advocates. During this session, the list of the witnesses, the matter to be raised at the full hearing, should be can be tabled on the table of the judge. The discussion could be raised, and then some settlement can be achieved. During this session, in-house counsel can try to pray that he's supposed to be not involved within the list of the witnesses, because his position is an attorney to the corporate defendants, so that he's privileged. Their conversation and all correspondence are supposed to be privileged and not to be disclosed without the consent of his employer. But other techniques during the trial, the counsel could object on the argument for none of disclosure of in-house counsel as witnesses. He can try as much as possible to object to every question raised against him on the ground that he was employed as an attorney to his client or his employer, so that he is supposed to enjoy the privilege for their communication, and or the other way around, he can try to argue that he doesn't have a first-class information, so he cannot submit the evidence which should be admitted before the court. As you know, in-house counsel is not being involved in every transaction of the corporation. It is more concerning with the legal matters. So being summoned and appearing before the judge for testifying before the court, some of the information is all first-hand information for him to submit before the court. So he has the room to claim and argue before the judge that the information he's having is not first class. So technically they are hearsay information, hearsay data, and they're not supposed to be admitted. On the other way around, in-house counsel he can try to argue and object before the jury that what he can offer is not an expert opinion, rather it is only technical evidence. For this, as we know, technical evidence is what we can take us into more or less presumption, and presumption is not admissible at the court. So at this point, he can try his best to argue and object that he's not qualified as a witness before the court. On the other way around, in-house counsel, he can raise some objection on the fact that if he's been called to testify, some documents. The argument he can employ is that once the document is authenticated before the court, that means the documents speak by themselves. So there's no need for him to be available and testify on the same. The court should rely and on the document as long as this document has been properly and sufficiently authenticated. Then there's no need of him to testify on the same. Let's try to talk about when can an in-house counsel be involved in court matters. There are some environments in which in-house counsel can be used, can be needed for some matters at the trial, during the trial. It is only when the employer himself requires his lawyer to testify on the matter before the court. But before this takes place, any in-house counsel should make it very clear to the employer that the risk which can be available for him to testify in the court. Because technically, this is too risky, as we have already said. And if the employer requires his in-house counsel to testify before the court, he should be made aware that there are some areas this in-house counsel can be compelled to testify before the court in which the interest of the employer can be at high risk. So this fact should be brought to the attention of the employer before this can be done. Additionally, let's talk about how should the in-house counsel conduct himself during the hearing at the court. The in-house counsel should be prepared to raise as much as objection before the court, praying that whatever he is supposed to respond is technically keep putting his employer at the risk and waive the privilege which provided by most of the statute in many of the jurisdictions. I know in some jurisdiction this privilege can be waived, but suppose it's, for instance, in Tanzania, the conversation and correspondence between the attorney and his clients, which including the correspondence between the in-house counsel with the employer, they are privileged communications. So in-house counsel, when it appears before the judge, he should, at his best, tries to raise the objection as much as you can, or arguing that this is a direct removing the privilege of the conversation between the client and the in-house counsel, his attorney, which is very unfair and it is illegal. There's some point at which usage of external counsel is really necessary and unavoided. External counsel can be employed when all alternatives of settling the dispute have been employed and have failed. At this point, the employer is highly advised that he should use external counsel instead of in-house counsel. In this regard, at this point, in-house counsel should cooperate with the external counsel trying to move the matter forward, but not to the trial, a full trial. What the in-house counsel can do, at this stage can be very, very beneficial to the employer, but for the sake of avoiding the risk attached to the with the in-house counsel appearing before the full trial, is better that at this stage external usage of external lawyers is unavoided and high importance. So in winding up, I would like to give out my honest and strong advice to the in-house counsel that it is undisputed fact that usage of in-house counsel can be very beneficial even during the trial, but the magnitude of the risk attached with this conduct, it is highly recommended that you stay away from the court and leave this assignment with the external counsel, which is more safe for yourself and more beneficial to your employer. Thank you for listening, and thank you, moderator.
Thank you very much. I think now in-house counsel, when called upon to be witnesses, they'll be able to handle that better. Our next presenter is a lady. At least we had two ladies in today's session. She will take us through how to manage difficult relationships with the external counsel. Her name is Dorothy Masifa Ochola. She's head legal and company secretary for Standard Chartered Bank in Uganda. She's an accomplished banker with over 11 years of commercial banking experience. She has worked in various other banks in Uganda. She holds an LLB and is an advocate of the High Court of Uganda. She also has an LLM in commercial laws from the University of Cambridge. Welcome, Dorothy.
Thank you very much, and good afternoon, everyone. It's an honor for me to be here. When I was thinking about what to say this afternoon, because it says managing difficult relationships, so I will start off with summarizing from my experience when the relationship has been difficult. The ideal is, and I like to look at external lawyers as an extension of in-house counsel. That's how I like to look at them, as partners, as members of my team. But from experience, there have been scenarios when the relationship has become difficult. So I'll start off with summarizing those, and then more importantly, explaining how we can avoid those difficult relationships. And relationships can be difficult if there is distrust, there is confusion, especially around billing practices. And if there is no clarity, there is no consistency, and there is no open communication. So I've found, for me, the critical bit I look at for an external counsel, if they are very busy or they do not diarize a matter well, then that is very unfortunate. So for me, that is a key issue. Being too busy or failing to diarize properly and missing deadlines, and also doing work last minute, because those things can come out. Sometimes I always tell my business partners, I'm not going to do the work if I have passed it on to an external counsel. Otherwise, what is the point in paying a very hefty bill? So I find, for me, the key issues that cause the relationship to be difficult: very busy, doing the work at the last minute, and also trying to do work that is not within one's specialty. I know it's important when we hire the firms. Firms can profile themselves And also I've seen where the profile can be very selling or like a marketing thing. And then when it comes down to doing the work, there's a bit of a challenge. So I think that that area also needs to be looked at. And also when there is an issue, giving advice off the cuff. Sometimes you might find you're asking an external lawyer question, they're giving you advice off the cuff, which you're also not very comfortable with. So it's very important for one to do their homework. So those are very critical areas which cause the relationship to be difficult. Another is when you can clearly tell that the external counsel has just used the precedent and maybe not changed names, not changed scenarios. So over-reliance on prior documents, which may not even fit the current scenario, is something that might cause strain in the relationship. And failure to document discussions and decisions, lastly, so that you can't go for a meeting and then at the end of the day, you're wondering, I'm not receiving an email summary of the proceedings, what is happening? And then you end up having to send that yourself. So for me, in my 12 plus years, I started off as external counsel, and then the bulk of my career has been as in-house counsel. So for me, those are key issues that cause the relationship to strain. But what is important, because I mentioned external counsel are an arm of us, is just if there is a breakdown in the relationship, openly discuss the matter, clearly explain the issue, and then trust and open communication will help mend that relationship and also go forward fruitfully. So I'll highlight about 7 tips which I have found over the years have really helped to build a very solid working relationship between myself as in-house counsel and external counsel. And I like what the keynote speaker, Ife, said. One has to, as in-house counsel, one has to become part of the business. And for me, even when I'm looking for a new firm or when I'm expecting work, one of the clear ways to do this is to set expectations about what services I expect from the external counsel. So I don't expect just external lawyers, but I expect them to be a strategic advisor to the company, because as in-house counsel, we have to come out of our technical shells, regardless of what industry you're in, and understand the business so that you use that technical knowledge to become a business enabler. So even my people on the panel, the external lawyers, I expect the same of them. But it is my responsibility to explain to them the business, but I also expect them to read my annual reports, go to my website, the company's website, understand what is happening, so that when I come to them with an issue, they can be able to put that in perspective and give me the advice that I am looking for. So that for me is a very, very key area. But as in-house counsel, if we explain what we expect of external counsel, then that will make the relationship very smooth. The second key thing for me is flexibility on fee arrangements. And this is an issue that I've seen causes a lot of strain. And if in-house counsel want this to be a success, then you have to give your expectations to external counsel where fees are concerned. There is no business leader that wants to be surprised with an invoice on the 29th day of the month when they are closing accounts in 2 days and when they are not expecting it. So it's very important for external counsel to understand how your business operates, to understand that when you give an instruction, you need to agree on a fee, and the fee needs to be reasonable. And this should also be documented in service level agreements. Otherwise, there is nobody that wants to be surprised with a very, very huge invoice. But added to that, flexibility on fee arrangements. I find that billable hours are a bit out of fashion, because as I've explained, I expect external counsel to consider themselves as part of my team. That means that if you're on my panel, you're being retained, you're getting business automatically. So don't bill me like somebody who has just walked in, but also you need to provide value-added services, which should be ideally free. And then also, you need to send in your team so that they can understand the business. That can be through secondments, etc. So the flexibility on fee arrangements should not be traditional. There should be some kind of flexibility, but also the services should be value-adding. If, for example, I give you an assignment and you can send me a 10-page summary, rather you can send me a 10 bullet point email with a summary of the legal opinion. Why should you send me an email and then you send me a 20-page memo, which you're going to charge me for, and then I have to go through sections and clauses in the legal opinion, and then I have to Google for something that I don't understand. So I think that that flexibility on fee arrangements, external lawyers need to consider a lot more how to make that better. And that leads me to the next issue about avoiding legalese. Every in-house counsel that has spent more than 3 years in a company will understand that it's really not about the technical terms that you used in law school. Nobody really honestly cares, even when they are asking you to solve a problem. That is what is important. What is the solution? Not what does the law say, and that the keynote speaker touched on. It doesn't matter what the law says. What actually matters at this point is how can the problem be solved without causing any legal risk to the company. So legalese from external counsel does not help us as in-house counsel at all. And that is an area that really, if it's worked on well, will help. So what should come foremost? And I see when I read so many opinions, they are very good and I like reading. But for me, when I'm writing an email to a business colleague in-house, what's the first paragraph has the answer. So I've looked at the question. So I'll say this is what we should do, and this is why I think we should do it. But you'll find that legal opinion from external counsel will first give you 10 options. So by the time I usually actually first go to the conclusion, and then I come back to understand the justification. So the whole legalese and technical language can sometimes strain the relationship, because what we are actually looking for is what is a solution to the problem that has been identified. And the next thing is about providing thorough, honest input and documentation. I know that it's challenging for external counsel who are not specialized in a particular area of business. I work in the financial industry, and I find that most times I have to explain how we operate, which is understandable. And it's also important for us to avoid relationship strain or misunderstanding, provide all the information that the external counsel needs. But also, it's important for the external counsel to build a practice in a particular area. If you want to serve in the telecom sector, in the financial industry, build a practice so that you can understand whatever you're given. But providing the proper documentation for us as in-house counsel, and also giving the external counsel the proper picture. If something has actually gone wrong, it's important to clearly articulate that I think there's a problem here. How are we going to go about it? And then also for external counsel to be open enough and say, I don't think this matter has much chances of success. Let us just settle it, or this is how I think the matter should be resolved. So I think that open and honest communication, whether it's documentation or it is just communication, should be very clear between both the parties. And the last thing I would say is sending timely input and thorough feedback. I've found that thorough feedback and thorough review of documentation on both sides. I've found that there's something that one of my line managers told me: inspect what you expect. So I've found that even if I trust the external counsel or I trust the firm, I have to also check the documentation, because the worst that can happen is something gets filed and then you're surprised by 2 paragraphs in there that you are not able to check. But also for the external counsel, there are so many, you find firms that are very big, and maybe sometimes the work is delegated to somebody junior, and then you review it and you're wondering whether it had that quality check. So on both sides, it is very, very important to review the documentation, agree the expectations per project, check in on how the project is going. And for us, the most common projects, it could be a deal, it could be a matter in court. But I've found that if there is no open communication, surprises can come up later, maybe at one hearing when there's an interlocutory application that scatters the entire matter. But because both parties did not take the time to agree the deliverables, agree the outcome, review the documents, or even sit down and touch base in the course of the matter. So I think that if those areas are touched upon, then what would otherwise be a difficult relationship becomes a very, very good one. Because like I've said, for me, external counsel are part of my team. If I'm not in, I can even ask somebody, please contact this external counsel if one of my team members is not able to handle it. So I want that, because of that, I want the relationship to be a very, very fruitful one. And there are several ways that that relationship can be made better. But one of the most important things is just open and clear communication, and making sure that as in-house counsel, external counsel thoroughly understand your business, and to the point where the business team or whoever it is can reach them directly, because they know that when they are speaking to them, they'll be able to understand. If something goes wrong, the relationship is strained or mistakes happen, just like human beings, it's just open and honest communication. Don't stop giving them work when something has gone wrong, but sit them down and explain, this is what went wrong, this is how I think you need to improve, and then the relationship will be better. So I'll hand back to you. Thank you very much.
Thank you so much, Dorothy. The practical experience is very good for those in in-house practice, and I think after today, they will implement some of your experiences and the tips that you have given us, and they will have a smooth relationship with the external counsel. Now we'll move on to the plenary, where now participants, you're free to ask questions. But when you want to ask a question or make a comment, a remark, please raise your hand. There is an option for that. Raise your hand virtually. State your name, your organization, your country / national bar, and also indicate the panelists that you'd wish to answer your question, or the remark is towards which topic. So we'll now take your questions. To the panelists, I request that you look at the question and answer portal and try and respond to those as we wait for participants. We have about 11 questions. There is one, somebody asking, that's just a comment. Is somebody saying that I think the role of in-house counsel is more of multitasks rather than aspect of legal issues of your company. Therefore, one has to have more than legal knowledge stroke skills. Otherwise, you'll find yourself not very useful to your organization. I'm trying to see. Okay, there's a question. How do you deal with investigation agencies investigating issues in your organization? Perhaps I may ask President ZLS to respond to that, or any panelist who has tips on that, on investigation agencies. And I know this is very relevant to us in Kenya. There is a lot of investigation going on in our state corporations, and of course, in-house, the head of legal is the one most of the time tasked with this.
Hello? Hello?
Yes, please proceed.
I was looking for the, well, I was looking for the question from the court, but I've never seen it. But I think the question is, how do we deal with the investigation authority, isn't it?
I think perhaps there's more than one. You can combine them.
What other number of, I'm at question number 1, without professionalism. No. Read life, no. I think the question is how do we do with the investigatory authorities, right?
Yes, please just proceed, Mr. Abdallah.
Okay. Thank you. When it comes to collection of evidence by these investigatory authorities, technically you are supposed to give out what you know according to your position. But the thing is, the thing could be, what if you will be invited before the court and testify according to what you know? That way the question could be a very bit complicated. And at this point, because this is going to be sort of a criminal matter, and there's no way you can avoid yourself. So at this juncture, that is where this is the point where this is like a point of no return. There's no way you can avoid this legal obligation, but you have to be very, very careful in the sense that at all times you have to protect the interest of your employer. So whatever you'll be testifying before the jury, before the judge, whatsoever, you must know your limit, and you must know who you are and your position within the corporation. That's my simple view. Thank you, moderator.
Okay, thank you very much. I believe that has been helpful. Your response has been helpful to the person who asked and to the rest of us. Madam Ife, someone has requested that you share the most challenging time and how you navigated this. Somebody would just like to know your experience. We seem to have lost you, Madam Ife. There's another question. We seem to have lost Madam Ife, so I will read another question. Without professional indemnity, is it in order for the in-house counsel to represent the employer in court in his or her individual capacity? Dorothy, perhaps you may give us your thoughts on this.
Okay, thank you very much. I saw that question, and I'm assuming that it's asking represent as a witness. So what I've seen is that when one is still employed with the respective company that is in court, we all know the principle of vicarious liability. So if an employee, and when staff are acting in the course of their duties, they are also really acting on behalf of the company. So for me, what I've seen is when the person is in the organization, they are protected. The company will provide the external lawyers, they'll provide all the support that is required. What I've seen from my practice, the situation that becomes challenging, as I said, I'm in the financial industry, is where the staff are now the suspects. So I've had scenarios where police will come, it's a criminal matter, they'll come and they'll pick up the person, and there's not much you can do, of course. And what makes it even more delicate is where there's a suspicion that this person has committed a disciplinary infraction. So the challenge that I've seen there is, do you provide protection to this person, or do you let them fend for themselves? But where there is no suspicion of commission of infraction on the staff's part, I have seen the staff are fully protected, whether it's going to police to give statements, whether it's going to court to give statements, they are protected. Where it becomes a disciplinary matter, it's always a thin line, and so many stakeholders have to be consulted before anything is done, because the person might be out on disciplinary suspension and yet they have not yet been found guilty of the crime internally. So how do you handle that? So I've found that where there is no disciplinary issues, that is clear cut. So when you talk about professional indemnity, I've not seen that for staff. I've seen that with either external counsel or people on the board. However, I have seen that once somebody is carrying out their duties, they are provided with external counsel support and the respective protections as a member of staff. So that's how I'll answer that.
Okay, I believe that suffices. Another one, what are some of the traits, or at what point in time will one realize that he or she needs to take the path of being an in-house lawyer? One thing we are always told is to identify your path earlier enough, or pick your struggle and struggle with it, as somebody loosely put it. I'll ask Madam Ife to just give some input to this. This is more like mentoring.
Okay, I hope it is clear, able to see me and hear me without any background noise. Is that the case?
It is okay now. We can clearly hear you.
Okay. So anyway, I maybe I'll just take a minute to answer the previous question. I think one was about the most rewarding moments I've had in my career, and I want to say that there have been many. But I think for me, what I enjoy is when I actually see the results or the fruits of my work. One of the things I do at Google particularly is, do a lot of product counseling, due diligence, and work with engineering teams to make sure that we're able to roll out our products in a manner that complies with relevant rules and regulations. And so it is really great and rewarding to see when the products are rolled out and when they have a positive impact, on the community. So that is really, really a rewarding moment. As regards challenges, challenges continue all the time. And I think in my role, one of the challenges I come across severally is the fact of working in situation that is in a company that is fast moving, where technology changes every day, and working with that in the midst of an unclear regulatory environment. So a lot of the times there are no clear laws that govern some of the products that we're working on, and it really just takes a lot of creativity, and trying to think outside the box, be able to figure out, how to work on certain products, especially when you have a dearth of legislation, or there really isn't any clear guidance about how regulation would apply. So that I think is a continual challenge, and I think just for anybody in the technology field. Now, in terms of career, knowing how, whether you want to take the in-house counsel path, I don't know if I'm the greatest person to give this advice, because it took me 10 years to go into the in-house counsel path. And if you had asked me when at the beginning of my career, if I knew I'd be headed to this path, I would say no. I actually was hoping to be a litigator. That didn't happen because life always happens. So what I say is that don't be too hard on yourself if you don't quite know what you want to do right away, or if you don't quite know what your path is. I think you keep yourself open to opportunities, and have the courage to take on, opportunities that present themselves. Because the truth of the matter is that there will always be opportunities, and what makes the difference is if you take them on, try them on, and hopefully in the process, you're able to find what makes you happy. So it took me a couple of tries, but I think I'm happy doing what I'm doing now. So as I said, you may not always know this
We lost you just as you were concluding.
Great.
Okay.
I did finish. Yeah.
Oh, have you finished?
Yes, I have. I have concluded.
Oh, all right. Thank you. We have two presidents in this session. We have the ZLS Zanzibar and the ELS president. I want to call upon the ELS president, Mr. Bernard Ondo, to check from the participants who have raised their hands and just take their questions. Mr. President, karibu.
Asante sana. Thank you so much, Goretti. I think let's try and conclude the question and answer session. I see no hands up on the attendance list. I can see that most of the questions have been answered in the Q&A section. Maybe the couple of questions which may not have been answered, we'll just ask one, and then we'll ask the panelists to give their concluding remarks. To all the panelists, having worked, let me just read the question. The challenges for in-house counsel is that they are sometimes considered as knowledgeable or be involved in everything. And this push to be in everything, they are pushed to be in everything, including meetings. How do you deal with these lots of work? How do you balance? I think that's the question that some of the participants have asked. Let me ask Ronald. Ronald, what's your take on this question? How do you provide that balance?
President, thank you for the question. Could you please repeat it? My internet is a bit choppy.
Sorry. So the question is, most times in-house counsel are considered to be very knowledgeable, so they are involved in too many things, including meetings and other functions of the company. How do you balance the work of an in-house counsel?
Thank you for that. Yeah, look, in fact, that is the appropriate word. Balance the work of in-house counsel, because like the saying goes in East Africa, in-house lawyers or lawyers in general are referred to as land friends. So as such, there's this perception that, you know, somehow you know a little bit of everything, and it really boils down to how each individual lawyer shows up within their own workspace. So they are, you know, in-house counsels that come across as quite knowledgeable and naturally get drawn into a lot of other things, even non-legal related. Or there could also be ambition on the part of the in-house counsel that sort of drives them to project, you know, a sense of them being available to facilitate. But having said that, once you're also available for everything, then you're also not available for particular things. And it's upon each individual lawyer to sort of find that sweet spot for themselves. You know, when are you most comfortable within yourself? And this requires, over time, a sense of reflection on your part. When do you feel most comfortable sort of providing value? Because ultimately, as an in-house counsel, your job is twofold. Your job is to maximize the rights of the organization and to mitigate the risks of the organization. So if you think of your job in that sense, you cannot obviously be available for everything. Be for critical, and critical things may vary from organization to organization, individual to individual, right? So I guess one needs to reflect on when they're most productive and helpful to that overall objective of the organization, and strike the balance there. I'm not too sure if this responds to the question, but it would be different from lawyer to lawyer and organization to organization. But you cannot stretch yourself so thin, else you sort of run out of steam, so to speak. So over to you, President. I'm not too sure, you know, I can elaborate further, but I'll leave it at that now.
Thank you, Ronald. I think you raised the point of when do you find yourself to be most valuable to the organization. I think that's a key consideration of trying to find how you balance between the lots of work that in-house counsel is given. I'm going to ask all the panelists to give their concluding remarks in view of the time. We have 8 minutes to 4 p.m. So I will start in the order in which we started. I'll ask Ife to give her concluding remarks, and if there are any questions she feels she needs to answer, she can answer them during the concluding remarks. Ife, offered to you. I'll also ask all the panelists to kindly put on their videos so that we can have.
I think I just want to reiterate one point that I mentioned in my presentation at the very beginning, which is that, you know, these days it's not enough to do as in-house counsel. It's not enough to do the legal, you know, to do the legal thing. It is important to do the right thing. So I just want to encourage everybody, even as you work in your different organizations, to ensure that you take a broader view of things and strive to do better than just providing legal advice, making sure that the advice that you provide is not only legal, but it is right. It is possible to actually have legal advice, to provide legal advice that may not necessarily be right for the circumstance or for the company. So very, very interesting to make that distinction, but also, you know, making an effort to ensure that we strive towards doing what is right and not only what is legal. Thank you.
Thank you, Ife. Over to you, President Slim. Give us your concluding remarks, please.
Thank you, Mr. President. First of all, this has been a very, very interesting topic, and I've been counting the number of participants here in this my third appearance on webinar series by East African Society. This is the highest, this is the only webinar with the highest number of participants with a big number of questions. So I feel very proud and privileged to be invited for this event. And I believe that we have touched the lives of many young lawyers and the rest. I have a friend of mine who is not a lawyer, who has been online following our presentation, and this is very interesting. On the other notes, it's better for in-house counsels that they, apart from limiting themselves as advised by previous speaker, that they should try to understand the nature of the business. If you're working, for instance, I've been working in aviation industry at Zanzibar Airport Authority as a company secretary. Apart from giving out legal advices and going to court, I've been trying my best to do a lot of short courses on aviation, and I've been trying to participate in various activities so that I can be more conversant in aviation. And with time, I became very, very interested on the same. So thank you, Mr. President.
Thank you so much, President Slim. Herbert, over to you for your concluding remarks.
Yeah, thank you. As we've seen during this conversation, the job of the in-house counsel has become very complex. So it has to take into consideration many aspects, and among those that are the strong relationship you should have with the all stakeholders. And I'm happy I've been able also to get to learn from other colleagues. For us who work in a French-speaking environment, it's good to have those input from the other members. So thank you very much. Hope for future discussions. Thank you.
Thank you, Herbert, for your concluding remarks. I will ask Dorothy to share her concluding remarks too.
Okay, thank you very much, Mr. President. And I'll just quickly go back to the other question that was asked. I have some friends who are colleagues in Kenya, so they've clarified an issue. I think the attendee was asking from the Kenyan context about being a witness without, rather representing the company without professional indemnity. I would say that is not a wise decision. If I was asked, it's a question of capacity. If I was asked to go and represent my employer in a matter, I would first of all think about, am I even going to be able to do it? What seniority do I have before court? Even if there is vicarious liability, there is no professional indemnity as we know it. And there's also, so there's an issue of capacity, the professional indemnity, and usually we are witnesses, so there's also that conflict. So I would say not recommended. Let the external counsel do what they are very good at. I would not recommend that at all. So my closing remarks, in-house counsel is a very, very good place to be. It opens your mind up to worlds of possibilities. So for me right now, I consider myself a business advisor who studied law. I actually say I am a banker with a law degree. So that means I can move across companies, I can do so many things, I can move across departments. You get so many other skills that you can deploy, with the primary one being legal analysis and communication. So for me, it was an honor, Mr. President, to be on this panel. I've learned from all the speakers, and I would encourage our colleagues who are in in-house counsel, please continue doing what you're doing. And to our colleagues in law firms, we appreciate you as well. You are a very, very strong support system without which we cannot be successful. I wish you all a good evening. Thank you.
Thank you so much, Dorothy, for your remarks. I'll ask, lastly but not least, Ronald.
Thank you, President. Well, first of all, thank you for the opportunity to share in this community of lawyers, in-house and external. And grateful for my fellow panelists. I've learned quite a bit. I guess my parting remarks here is a challenge to my fellow lawyers in-house and maybe external as well. We live in, challenging and difficult times now. And if anything, Corona has told us that anything is possible. At a drop of a hat, we can get stuck at home. And with that in mind, I would implore everyone to, keep an open mind to the possibilities that are out there. My colleague said, go beyond the law. I think that anyone can read the text. Go beyond it. Invest in yourself. Grow skills around, the foundation that you already have. I think that we've been sort of gifted with the opportunity to know what we know now and what we've learned. I think that for anyone to survive in this age of AI and global pandemics, one skill transferable. Like my sister Dorothy says, be the banker with a law degree and not just the lawyer. To go beyond would be what I would challenge everyone to do. Thank you.
Thank you so much, Ronald. I think with your concluding remarks, we shall go beyond. I think that's the note that I have taken from this in-house lawyers webinar series. As we conclude, I'd like to remind all of you in 1 minute that East African Law Society is going to be able to share in-house counsel webinars every month. Every month we shall be having an in-house counsel webinar so that we continue to discuss about the challenges that we have. We continue to encourage one another and continue to inspire one another. East African Law Society membership, please ensure that you pay your membership, because I think after next month, only members will attend the webinars. Just for purposes of giving you that information, between 0 to 2 years, you're only supposed to pay $10. Between 2 to 5 years, $20, and over 5 years, $40. So please ensure that you pay your membership. You can actually pay your membership using our portal. It is online. That will help you save a lot when it comes to the paid up webinars, where we shall have extremely relevant information to be shared to the members. So please remember to pay for your East Africa Law Society membership. Lastly, our panelists have agreed to mentor at least one in-house lawyer. And the only way to get the first 5 people who send an email to Mr. David Sigano, I think he has shared his email, will get the opportunity for membership. So I want to take this opportunity, number one, to thank our panelists. Thank you so much, Ife. Thank you so much, Dorothy. Thank you so much, Ronald. Thank you so much, Herbert. Thank you so much, President Slim. Thank you so much for taking time to share your experience. I have received several comments that point to the fact that your conversation has been very inspiring. In fact, one of the comments I have received is, I think, a comment by Ife where she said, pick your struggle, or I don't know who said, pick your struggle. And someone, I think, said, that is the story of my life. So you can see that members are following and have been inspired by what you have stated. Thank you so much. Let me take this opportunity to also thank our moderator, our treasurer, Goretti. Thank you so much for sparing the time. Let me thank our secretariat who have been courteous enough to organize this webinar. Thank you so much. Let me now wish you an early weekend. I know some of your weekend starts on Friday, so let me wish you an early weekend, and let's look forward to the next in-house counsel webinar series. Thank you and have a good evening.